rarely see here in Senate Judiciary,
Oh,
because we spend so much time on criminal law.
good morning.
Good morning. Although on e-filing, Terry Corsone's Senator Benning may start the meeting this morning, letting you know about a problem he had this weekend with e-filing.
Oh,
3 hours
Well,
yesterday.
we are
Terry.
live on YouTube, and this is Senate Judiciary on Tuesday, April
13.
13th. Thank you. Thank you all. Senator Benning wants to let one of our witnesses know about his experience this weekend with e-filing.
So Terry, the short version is I have a client who had 22 separate dockets. Several of those dockets had multiple counts. And when you go in to search for the individual, he happens to be a frequent flyer. And the downtime for getting the search to complete is usually about 60 seconds for each time you hit it. So right off the bat, you've got at least 25 or 6 minutes worth of time that you're waiting on the system. In order to get this gentleman's plea agreement through, you have to first send all the documents down to where he is incarcerated, get them back, then send them to the prosecutor for that prosecutor to sign, get them back because they haven't figured out yet how to file all this apparently, and then turn around and file all the documents one at a time. And it took probably about 5 minutes for each one of those 20 some odd cases to be entered into the system. It took me 3 hours to complete that project. And normally it would have taken about a half an hour at the courthouse with the prosecutor and the defendant and myself sitting there writing out documents. I'm hoping that's an outlier, but it was one miserable experience yesterday. And
oh
I
my.
thought you'd enjoy that.
Well, Senator Benning, with your permission, I know this top clients with multiple dockets, and it's my recollection that it was something that they had on their list, but I'm more than happy to follow up because we are channeling, suggestions. And Pat Gable has agreed to let us reinstate the court user group that was convened as a result of Act 120 to meet with the judiciary representative. So if it's permission, I'll add this to what we're bringing up with them to see what can be corrected.
Be happy to give that explanation. My nightmare would have been, they would have kicked it back and said, you have to file the plea agreement, then you have to file the restitution judgment order, then you have to file the notice of collateral consequences, then you have to file the probation order. That would have been a killer for me. But luckily they accepted them all under just the words plea agreement, and I filed them all at the same time in the same envelope. But the clerk did tell me this week we'll do that. We don't know about next week, whether that'll be possible.
Well, we'll add that to the list, but we're asking when people have these situations to let us know so that we can at least alert them and do what we can to help make the changes.
Thank you, Terry. I know that's
Sure.
not what you were here to testify on,
That's
but
okay.
it's always helpful to get an update on how well our new system is working for the
Thank you.
players within the civil and criminal system. Moving right along, H-199 is an act relating to validating legal instruments used in connection with the conveyance of real estate. Sounds very, very complex and complicated. And so, Eric, could you tell us what H-199 will do? As passed by the House make changes so that we should be looking at is it a strike-off?
Well, it's the bill as passed by the House. That's the version to be looking at. I think it's on, I
Okay,
think Peggy put it on the web page, the committee's web page.
I've got a copy of it here. emailed to me. or
Can I
sent.
just make a request?
Yep.
And I don't know who this would be to, but whoever sends us the hard copies of the bills, and I do like to have hard copies, always sends us as the House bills as introduced, not as passed by the House. And so it's very difficult to, because I've got 199 here, but I've got it as introduced, so I have no idea. I mean, I can go on my website and print it out myself, but doesn't make
Okay.
any sense to send us all the copies of as introduced.
Yes,
True.
I did clarify that with Tony.
Oh, okay, thank you.
On page 1, Eric, it seems like a very dramatic change.
No dramatic changes in this one. But this is one of those bills where it might be helpful for me to, before
Okay.
we dive into the language, just tell you for a minute or two what's going on in the bill, because there is a lot of legal terminology, as you can see when you look at it. And I'm just realizing just now that I believe in this particular case, although we know it's unusual for a bill as introduced to be the same version that gets passed, I don't think there were any changes actually made between the as introduced and the as passed version. So in this particular case, you have the right copy in front of you. Although your point is well taken, Senator White, that we need to make sure that you have the right as passed version, because most often the version that passed is not the same as the one that's introduced. This is one of those rare cases when fortunately it works out for us. But anyway, quick summary of what's going on in H-199. Basically, what the bill does is it provides for the cure of technical defects in documents related to selling real estate, and in particular powers of attorney and deeds. And you already have a statute on the books, in fact, that does exactly that. There's a 27 VSA 348, which is the statute that's amended in H-199. That statute right now allows exactly this sort of thing to happen. When there are technical defects, non-substantive technical problems in powers of attorney, deeds, other documents related to conveying real estate, transferring real estate from one person to another, they are cured if they are recorded properly in the land records and nobody challenges them for 3 years. So there's a general, you can almost think of it as a statute of limitations. The general rule is that for documents related to real estate, if they're properly recorded for 15 years and nobody challenges them, then they're valid. So if you come in on year 16 and say, oh, there's a problem with the deed, well, if it's year 16, it's already been recorded for 15 years. You can't make that kind of claim. But there's an exception for technical defects, which is where that 3-year period comes in. There's like a list of technical defects related to the documents, the deeds, the powers of attorney, et cetera, that if it fits into one of those categories on the list, one of these more technical, non-substantive defects, then it only has to be recorded for 3 years before it becomes valid. So it's a shorter period, if it's a more technical problem. Does that sort of make sense to everybody as a background so what S-199 does is it basically adds 2 more things to that list. To that list of technical defects, it adds 2 things. And they both arise out of the COVID-19 pandemic. They're very much related to, and I'm sure the committee will remember well, last year during the pandemic, you spent a lot of time talking about remote execution of powers of attorney and remote signing of wills. The whole reason for that was that, people didn't want to gather together in one office and, have a person executing a will and the attorney, the beneficiaries. And with respect to a real estate document, it's a similar situation. You don't want the seller, the buyer, the mortgage person, the attorney, the power of attorney, or the notary public, I should say. Since COVID, those folks have been trying to do these transactions remotely and not all gathering in one small office. And as a result of that, as you probably have heard, the use of powers of attorney has increased exponentially during COVID. And it's the technical problems in relation to that S-199 addresses. So I'll just tell you for a quick moment of background as well, that to give you a sense of what these 2 new pieces are that are added to this list of technical defects. The first one, if you think of a real estate transfer, right? Person A is transferring property to person B. Person A is the grantor. They're granting an interest in the property to person B. Person B is the grantee. And the way the real estate, the legal document that's used to transfer the real estate is the deed, right? The deed is the legal, the document with legal effect that when it's executed properly and recorded in the land records, that transfers the land from person, or the property, the house, from person A to person B. It's done via that legal instrument, the deed. If you think, and a power of attorney, just for a moment, think of that. I think the committee, as you well know, allows one person to act on behalf of another person. Power of attorney is executed, and a principal says, and I'm going to give these rights to an agent who's going to act on my behalf. And the agent can take action that legally binds the principal. Sometimes an agent is also called an attorney in fact. That's just another legal term, and it's used for the agent. So you think of the term power of attorney. It's not attorney in a lawyer sense, but attorney in a person on behalf, acting on behalf of another. So when you have a real estate transaction, or pre-COVID, you'd have the seller, the buyer, all probably gathered potentially with a mortgage person, with someone with a notary public, all gathered in the attorney's office to make this deal. And they all sign the documents and they pass them back and forth, and everything's done when everybody's sitting there in the same room. That hasn't been happening with COVID. So instead, what you've had is a lot of times the seller, the person who's selling the property, executes a power of attorney. And that power of attorney allows someone else who's working in the law office to sign all the documents for that. So they're acting on behalf of the seller. And the way it works, the way a deed, the legal requirements that the deed has to satisfy, is that the seller has to sign the deed. And when they put their signature on the deed, they are acknowledging essentially that they are doing it of their own free will. They're not subject to any fraud or duress, and they're making this decision to transfer the property. And that has to be acknowledged in front of a notary public. So the seller signs it, and that's called an acknowledgement clause. Even most deeds have this particular section called an acknowledgement clause. The seller signs it and they're acknowledging, yes, I'm doing this of my own free will. I'm not being influenced by anybody. And they sign it right in front of the notary public, who puts their stamp on it and says, yes, this person affirmed these things right in front of me. Transaction can move forward. But in COVID, with people not being together under the same office, as I mentioned, the seller is instead having, through a power of attorney, someone else in the law office sign their documents on their behalf. So if you think about it, that has led to some technical problems with this acknowledgement clause, because the sort of boilerplate of the acknowledgement clause says, yes, the grantor, the seller, was here in front of me when we transferred this property from person A to person B. But if you think what actually happened, they weren't there, right? They signed a power of attorney, and the only person who was there physically was the person acting under the power of attorney. The seller wasn't there. So the acknowledgement clause is technically wrong. So the deed essentially incorrectly says that the seller was there physically for the purposes of the transaction, but they weren't. It was someone acting under a power of attorney who was there. So that technical problem is the first thing that's fixed in S199. What it says is, and might be now a good time to pull up the language center series, unless you want to, that would be helpful. I think you're on mute, sorry.
Yeah, someday I'll be in person and not be muted. They'll probably force me to wear duct tape. You would think we'd learn after a year how to unmute. Thank you, Eric.
Sure.
Please, if you want to walk us through all the two changes. This is just real estate, though. It's not conveying a car purchase or some other
Exactly, or it
Only
doesn't
real estate.
relate to powers of attorney for healthcare or finances or
yeah.
anything else. None of that is included. It's only
Okay.
for purposes of a real estate
Just purpose
transaction.
For a real estate deal. Okay.
Yep, that's it.
Thank you.
So I'll pull up the language and just show you what I just referred you to, which is this concept that that when the real estate was transferred, the deed ends up saying incorrectly that the person selling the real estate, referred to as the grantor, was there, when actually they weren't there. It was, this is what you're looking at right here, by the way, is the existing statute that I mentioned that already provides for how these technical problems with real estate documents can be cured. So this is the list right here, the existing list. This is, because subsection A is what I mentioned is, you see the general period is 15 years, that line 2
Yep.
right below subsection A. So generally speaking, you got 15 years within which to challenge documents related to a real estate transaction. But we go on to subsection B, notwithstanding subsection A, notwithstanding that 15-year period, any one of these other documents related to a real estate transaction, you see on the top of line 2 there, is valid. That's the 3-year period, a much shorter window that applies for these technical, this list of technical flaws that may have happened in one of these documents. And this is the existing list. There's a defective acknowledgement. I just mentioned what the acknowledgement clause, that's where the seller acknowledges that they are, transferring the property of their own free will. There's another existing one in line 2 there that has to do with a corporation being listed, the opposite, an individual being listed as a person transferring the property when actually it was a corporation. See, another technical issue. Subdivision 3, an incorrect statement of the date. Subdivision 4 nowadays we don't so much require consideration, but this is an older statute. Consideration is what you exchange for the real estate, the money, whatever it may be. So whatever was exchanged for the property somehow wasn't included in the document.
Let me ask.
And lastly, here,
yeah.
subdivision 5, you see, is the new language. This is the one I just described. This is the proposed new piece to add. That the acknowledgement clause, that's the one where the seller, says I'm transferring it of my own free will, executed by an attorney in fact. Now that's as I said, that's another word for the agent. That's the person acting through the power of attorney. Inaccurately recites the personal appearance of the principal, and not the attorney in fact, who personally appeared on behalf of the principal. So you see, it inaccurately says that the principal appeared there personally, and that's the seller. The principal is the person who's selling the property. They executed that power of attorney, but they weren't there, and it inaccurately says that they were there, rather than saying that the attorney in fact is the one who personally appeared on behalf of the principal. So that's a technical flaw, obviously, that with the sort of incredibly increased use of powers of attorney, this has happened more frequently. And this adds this to this existing list of technical errors that has a 3-year window within which to be fixed.
Can I ask for an example? I mean, the last time I did any real estate, I was the seller, the buyer was there. We each had lawyers. We went to the bank. The bank, was there. We're all in the same room.
Right.
Right. So in this case, I'm not there. The bank's not there. Who's there? Just the attorney?
Sometimes, and other people in the attorney's office, yes, they can all be playing.
They don't do this over Zoom.
They can. I think that's also a possibility. You may recall
So,
in the.
So
Sorry,
this
go ahead.
only covers, let me understand, this only covers if the attorney mistakenly makes it seem like the principal was there. his
Yeah.
client was there when the client really wasn't there.
Right, because what actually happened was that, and it may be that the attorney is representing the buyer, but assuming that it's the seller, the seller executed a power of attorney sometime before the closing. Sometime before that, they drew up a power of attorney and said, all right, we're not going to be there. So we authorize, John or Jane X who works in your office to execute the documents for us.
Right.
So when the time comes for the closing, again, seller's not there. Someone else is doing the signatures for them. And they have to do those signatures in front of a notary public. That's the acknowledgement clause. And there's another person in the office who's a notary public, and they're there and they do it. But the acknowledgement clause says the principal was here, but the seller, who was also the principal, and whoever it was, Senator Sears, they weren't there. It was someone else acting on their behalf. So that's the
Okay.
mistake that's in the deed. Exactly.
And we're just saying that's okay, because
As long as it's only okay if it's properly recorded in the land records for 3 years.
and it's
If
only
nobody
for a
challenged-
technical error. It's not for a, you thought you bought 2 acres, but you really only got 1 acre.
Right, right. Would be a total
That came off the top of my head. I don't know why I think of that.
Right, right. Well, that's a good example, though, of a substantive mistake that wouldn't be covered by this at all. This is just.
But after 15 years, it would be, right?
That's an interesting question, whether that could, as to what falls under that 15-year, whether that's an actual substantive, like, difference in the amount of property transferred. I'm not sure off the top of my head whether that would come under the 15-year. Would that be
Yeah,
something that could?
what is this, Well, anyway, we'll go right ahead. I don't want to.
Right.
Sounds like pretty.
All right. So
Okay.
that, though, is the first of the 2 proposed changes in S-199 to sort of add to this list of technical errors that can be cured as long as it's been recorded for 3 years. That's the first one.
Hey, Eric, can I ask a question?
Yeah.
I've heard you use the term mistake on a couple of occasions, and it's been a long time since I've done any real estate, but isn't it really, it's not a mistake if the principal has waived their appearance technically by signing it over to an attorney. In fact, it's just the implication on the instrument, if I'm reading this correctly, that the principal was actually there, that we're just simply saying that's not a mistake. It's just the implication that's on the document that the person was there, when in reality that was not necessary. Am I wrong in that?
No, I think you're right. That's a better way to put it, Senator Benning. It may be a better term, really, is it's an inaccuracy in the document that's
Right.
that's created, you're right, by the fact that the person isn't there. So yeah, it's not a mistake. It's just that the document is no longer accurate.
Okay. Thank you.
Does that make sense?
Yep.
Yes, thanks for that, though. That's a better way to put it.
Can I ask
So
a question?
sorry, go ahead.
Alice, I'm just wondering, it's not really a part of this, but when does the actual sale occur? From what you've said, it's not when the people sign, but when it actually is filed in the land records? When does the actual passage happen?
I'm going to leave that question to the witnesses that you have today. I'm not 100% sure the exact moment in time that the real estate transfers, whether it's the signing of the documents or the proper recording of them. So might be a better one directed to one of the witnesses today.
Okay.
So hearing no further questions, I'm going to move on down to the second new piece that's added to 199. Now this, I'm going to take us back for a moment here before we look at the language, just to remind everybody of a bill that you passed last year. Remember, you passed language providing for the remote execution of powers of attorney. Now, remember that they referenced the emergency rules for remote notarial acts that were adopted by the Secretary of State. You remember this happened last year, and the committee discussed it quite a bit, that that the Secretary of State's office promulgated these emergency rules to basically apply that any time that a notary public was required to be used in statute, it could be done remotely. You know, because generally speaking, the way a notary public works is the person has to be physically present in front of the notary public, and they both, you know, they have to sign something, and the notary public has to physically witness them signing, and they put their stamp on it. But again, because of COVID, there was the issue of people not feeling safe being physically present in those sort of circumstances. So these emergency rules were passed by the Secretary of State that allowed them to be done remotely through secure audio video connections, that sort of thing. And as I had mentioned earlier, generally speaking, real estate transactions do require notary publics. The deed has the acknowledgement clause in it, and where the seller signs it and the notary public says, yes, that person was here right in front of me, and they put their stamp, their seal on it. And that's the way it was done prior to the pandemic. Now, these things can be done remotely, but there's a lot of technical requirements in these emergency administrative rules. Quite a long list. They're quite lengthy. And essentially what's being done here in subsection E is saying that, well, when a power of attorney, so again, you think about that, Senator Sears, you were asking that question earlier of, all right, well, who's going to be in the office now when these transactions are completed? There's far fewer people than there were pre-COVID. And you could have one person acting on a power of attorney for the seller. You could have another person acting through a power of attorney on behalf of the buyer. And even technically, the notary public doesn't have to be there either, because through these emergency rules, the notary public can do the whole thing through a secure communications link without being physically present. So just by saying all that, I think it's probably obvious that there's quite a large number of possible technical violations that could occur in that circumstance. So essentially what subsection E says is, all right, if you've got a power of attorney that's made, again, just for conveying or affecting real estate, not a power of attorney for, healthcare, finances, and anything else. It's only with respect to power of attorneys used in real estate transactions. If that POA, that power of attorney, is acknowledged and signed in the presence of a witness, then it's going to be deemed to be valid, notwithstanding the fact that it may not comply with the emergency rules or with the technical requirements for powers of attorney generally, unless within that 3-year period, someone challenges it as being invalid. So it essentially adds another circumstance to this 3-year window that's in existence for the other technical defects, and says, all right, if there is a power of attorney that's been made for selling a piece of property that doesn't comply with the emergency rules or with the other requirements for powers of attorney under Title 14, then it's going to be okay after 3 years, as long as nobody has challenged it during that 3-year period. Now you can see the very last line, this subsection shall not apply to a power of attorney obtained by fraud or forgery. So that's making sure that, because this is a bit broader than the previous one, it tracks, you see the existing language. If you look at the very top of the page, the previous the previous circumstance in which this 3-year period applies under existing law, under subsection D there, also has to do with powers of attorney that were not recorded happens to be what existing. And if the power of attorney wasn't recorded properly, it's fine as long as it's not challenged within that 3-year period. But again, it doesn't apply to releases, discharges, assignments to the document that were obtained by fraud or forgery. So that language is paralleled here as well. But essentially, that's it for this piece, which is that the failure of the power of attorney to comply with the emergency rules or with the power of attorney statute for purposes of a real estate transaction is not going to render the document invalid as long as it sits in the land properly recorded in the land records for 3 years and nobody challenges it during that time.
I
So
don't
those are your
wanna-
two.
Yeah, I wanted to keep the first comment that comes to my head is, what about a will that is done at this time during these emergency orders? Would a technical problem with a will be dealt with the same way, or will that be a separate bill? 'Cause
Yeah,
I
that
can
would-
imagine that wills will be particularly if somebody contests the contents of the will.
Yeah, that's a good point. It's not dealt with in this bill, but presumably the same issue could come up with respect to wills as well. Might be something to think about going forward, but yeah.
Well, we know there's already problems with wills.
We do?
Yeah, we had a bill that I remember Senator Baruth reported on, fixed those problems. I don't remember exactly the content. But it was pre-COVID,
Oh, pre-COVID, okay.
but I can imagine there would be technical errors in other aspects. All right. Well, thank you very much, Eric. Are there other questions for Eric? You could probably take that down now, Eric. Thank you.
Yeah.
Thank you for not showing us your Yankee.
Happy to help.
Our next witness is Andy Michael, who's an expert in real estate law.
Good morning, Senator Sears. Can everyone hear me?
Yes.
Great. First, yeah, thanks for the invite. Good to see everybody again, our annual spring get together.
Yeah.
For the record, Andy Michael, State Manager and Title Counsel at Caddick, Vermont's only domestic title insurance company. I work here in the South Burlington office. So, yeah, the first thing that's obvious is I think Eric's gunning for my job. I mean, amazing. Well done, Eric. I will maybe provide a little bit of color commentary, but yeah, you've laid out the issues and everything. So I think I can keep my remarks relatively brief. And those are that this is a COVID-related bill. The quick background is Vermont has, in my opinion, the single most complicated power of attorney statute in the U.S. Compounded by just an exponential increase in the use of powers of attorney during the pandemic. And I don't have actual stats, but I talked to hundreds of attorneys all around the state, and I would say, anecdotally, in ski area towns over the years, there has been a good historic use of powers of attorney because you have out-of-state buyers and they may not drive up to Vermont for the closing. So they give a power of attorney to the local attorney who signs the documents. So that was the norm going in. And now, so you might have, a power of attorney in a transaction every 4 or 5 transactions. Now, probably 85% or more of purchases and refinances involve the use of powers of attorney. And I have personally seen many transactions where a single transfer of real estate involve the use of 4 or more powers of attorney just for that transaction. Multiple buyers, multiple sellers, people all over the US or all over the world. So you layer that on top of the fact that the last 14 months, and I'm sure you're hearing and seeing it, have just been unprecedented numbers of sales and purchases, a lot of out-of-state purchasers coming to Vermont. That's a good thing. And the interest rates are, you know, we keep saying historically low, but they're historically low. So if people aren't, everybody's refinancing or buying. What the pandemic did, again, as you know, is it drove everybody to working remotely. So everybody's super busy, but the attorney is in their home, the paralegal is in another home, the seller and buyer are scattered about. So these documents, the powers of attorney, the deeds, the mortgages, are all being done by various people in so many different places. Now we'll take a buyer who's getting a mortgage. Eric's right. We all used to cram into the lawyer's office, buyers, sellers, realtors, maybe a lender representative, and you got 6, 8 people sitting around the table. Now what happens for the last 14 months is the power of attorney is prepared. It's sent to a seller or a buyer. Their first job is to find an actual notary. It's getting a little easier now, but you know, go back 6, 8 months, finding a notary was tough. People were driving through the drive-throughs at banks, putting the document into the, you know, the drive-through window, and it would be acknowledged through the window and through a microphone. It was being done in parking lots in the winter on the hoods of cars, slid under doors. So people were just doing everything they could. So if you take all this stuff, you say, well, what could possibly go wrong in a pandemic with thousands and thousands of powers of attorney? Eric's given some examples, and Senator Benning asked. Really, we're looking at essentially scrivener errors. The first section does fix the misreference to a buyer or a seller. And so the example I would use is most mortgages come from the lender pre-typed. And so in the acknowledgement clause, it says Andy, the homeowner, and his wife, the homeowner, and that's the way it's just typed because the software sets it up like that. Well, I've given my power of attorney to someone. It could be an attorney, it could be a paralegal, it could be my neighbor. And if they don't happen to look up and see that those names are there and they forgot they don't cross out personally appeared Andy and his wife, then we've got a technical error. So simply paragraph subsection B5 fixes that to say, okay, yes, it's a technical error, technical mistake. It's a slight misrepresentation, but we don't think it should affect the validity of the mortgage or the deed just because someone didn't look back up and fix the language. Moving down to E, this will fix other things like scrivener errors in 911 addresses. Remember, everybody is typing remotely. If it says, if I live at 1 Chipmunk Lane in Williston and someone puts 11 Chipmunk Lane in Williston, well, I don't own that property. So after 3 years, if no one has challenged this, is there really a problem with a typographical error that says 1 Chipmunk Lane instead of 11, or 11 instead of 1? Another example is there's a carve out in our power of attorney statute for powers of attorney that are executed within a 90-day window. And in my experience, probably 90+% of powers of attorney attempt to use that real estate carve out within the 90-day window. Sometimes people just make a biff, and I've seen powers of attorney that ran for 91 days or 93 days because a lawyer or somebody wasn't very good at math. Okay, That is a technical error in the power of attorney that would otherwise invalidate or potentially invalidate that power of attorney. So the language before you says, hey, if after 3 years with no fraud, no duress, a real estate power of attorney is a little more than 90 days or they missed the date, we're not going to throw the baby out with the bathwater. In terms of the remote ink notarization, that's the emergency rules promulgated by OPR or the Secretary of State or both. All good. My experience is there are not a lot of them being utilized, but it is a nice tool in the toolbox. One of the, as Eric laid out, it's all brand new. Nobody's ever seen or done one until, last March or April when it was rolled out. So the scenario presents itself that in, say, 5 years from now, a mortgage is in foreclosure or bankruptcy. And someone's trying to invalidate that, like a bankruptcy trustee. And the bankruptcy trustee says, hey, I read those remote rules. You are the where's the notary? Let's find the notary because the notary was supposed to keep the recorded evidence of the acknowledgement for 7 years. Well, maybe the notary can't be found. Maybe the notary is around, but the video is lost. Are we going to invalidate an otherwise valid mortgage 5 years from now or sometime thereafter because the notary didn't comply 100% with all of the requirements if, given the totality of the circumstances, the mortgage is otherwise valid? So I think this bill presents itself as a practical solution, a narrow set of cures or fixes, and it's entirely consistent with what the rest of 27-348 already does. So that's sort of my testimony. I have a couple of responses to pending questions if anybody would like me to address those, or
Yes.
let it come back up.
No, please go ahead.
So Senator Nick, I think, asked, when does the sale occur? And there are really two answers. The first answer is, as between a buyer and a seller, the sale happens upon delivery of the deed. So if there were two of us in a transaction and I'm the seller and I sign the deed and I put it in my desk, there's no sale. If I sign the deed and hand it to you, the buyer, as between the two of us, that sale is a done deal. You own the property. Why do we record things? We record them because that is notice imparted to the entire rest of the world that says Andy sold the property at Chipmunk Lane to the buyer. So the answer is really kind of two different parts depending on whether you're a third party observer or a party to the transaction. There was the question of wills. We kind of talked about that, but and it may be a very good topic. It was sort of outside the lane of at least my expertise. So we omitted it only because we thought the wills and estates people would have more to say on that particular issue. And I think that was it. If there are other questions, I'm happy to take a stab.
Are there other questions of Andy? Andy, thanks so much. Always helpful.
You're welcome.
Chris Dealey is our next witness, representing the Vermont bankers.
Good morning, Senator. Good morning, committee
Morning.
members. Pleasure to see you. Thank you for taking up this bill. We support the bill as passed the House and would ask you to do the same. I think Eric and Andy have done a great job of summarizing the issues. I'll just add a little bit more context. Andy's correct. We've seen an unprecedented real estate market over the last year, much to the surprise of many people. And it's just not individuals who are moving into Vermont. It's Vermonters who were either moving to additional properties or Vermonters who were refinancing their properties, some in part due to the financial situation they found themselves in. Due to COVID, they had some equity in their property and they needed to pull out some of that equity just to, again, meet their financial concerns that they were dealing with. So if you were to drive past some of my banks last summer and you see a bunch of people in a parking lot standing around a car, they were probably conducting a real estate transaction. Or to Andy's point, they were very much passing them through the drive-up teller windows. So we think this is a very narrow and appropriate way to cure some of those minor challenges, minor problems that may have arisen as a result of unprecedented activity, an unprecedented environment, having to work through the emergency rules that were promulgated. So again, we support the bill and would ask you to do the same. Thank you.
My understanding is that a lot of, Chris, thank you. My understanding is a lot of people are buying property sight unseen, that they're just, see something, I guess a virtual tour of the property. They may be in New York City or Miami or wherever, and they've decided to buy property in Vermont. Are you seeing that where that person never sees the property? Then I assume they get there at one point, may be surprised at the neighborhood or some other factor.
Yeah.
So
we've certainly heard of those stories that are out there of people who are just looking at the properties online or going through a virtual review of the property. And the reality is you would have multiple offers on properties. And the unfortunate, it's, I guess, a double-edged sword. The fortunate circumstances, if I'm the seller, I can do pretty well in getting a price that I want for the property. The unfortunate circumstance is that in many communities, it's driven up the price of housing. And that has had an impact on local Vermonters who may have a desire to move, buy up, whatever the case may be. So, the other discussions that you folks in the legislature are having on housing and the initiative with the new ARPA funds is really critical, because we've got to increase our housing stock in Vermont to help those people out who want to get into home ownership or have the opportunity to buy up, if you will. So absolutely, Senator, heard some of those anecdotal stories, lots of stories about people who wanted to get out of Boston or New York or New Jersey because of the pandemic. And Vermont's numbers were much lower than those other communities. And given the wonderful world that we've all learned about and being able to work remotely, many of us, it's an opportunity for those people to come here to Vermont. My wife and I would laugh as to whether they would stay after one winter in Vermont, because they may not have been used to it, but time will tell. But certainly some of those stories are out there, Senator.
Maybe they weren't aware there was a dirt road and they might not last through mud season.
That's true. That's true.
Anyway, I appreciate it, Chris, very much. I am a bit concerned about some of this market growth from a lot of areas, but certainly this bill, as I understand it, only seeks to deal with what, that technical errors that might have occurred. Senator Nitka, who lives on a
Dirt road.
who knows dirt roads.
Indeed. But I'm wondering, is this not still occurring now in closings that are happening today? Or have they done anything to change the software?
So I'm happy to jump in, and Chris.
Yeah, please,
also.
Andy, thank you.
Many lenders, yes, fixes have been done. It's not 100% of the time, but some lenders have figured it out. Some attorneys, once you make a mistake or two, you're a lot more careful. But again, remember, not all of these are signed in a lawyer's office or in front of an attorney. A notary can be anybody. I see a lot of notarized documents from non-attorney offices, and the notaries don't even use notary stamps. So, yeah, if it was just a lawyer problem, maybe we could address it, or just a bank problem, we could address it. But these things are, kind of everywhere. So it is better. It's certainly far from perfect.
Thanks.
I'll also add, Senator, we're going to obviously see the nature of closings change over the next few months because of the vaccine rollout, because of the administration's initiatives to open up Vermont more. I think we'll start to slowly get back to those normal in-person transactions that we had going on prior to the pandemic. So we're going to start to see that shift over the next few months.
Thanks.
Our final, are there any other questions of Chris? The final witness is Terry Corsones from the Vermont Bar Association. Thanks for joining us this morning, Terry.
Well, thank you, Senator. And for the record, Terry Corsones from the Vermont Bar Association. And just from the trial practitioner perspective, we posted the bill originally when it was first introduced in our property law section, and had no objections whatsoever to the bill. Practitioners recognize it as a helpful mechanism to address, to cure those very specific circumstances that may arise. And as Eric very nicely explained, have been in existence in the existing statute. This is to basically add two specific sets of circumstances that have arisen for the reasons that Andy and Chris have explained so nicely. Just as kind of an example, if John Smith gives Mary Smith a power of attorney, in the deed it would say Mary Smith personally appeared as attorney in fact for John Smith. That's what it's supposed to say. But as Andy said, if it came pre-printed, it might say John Smith personally appeared. That was overlooked when it was notarized, and this is simply to allow the transfer to go forward without that being a technical defect. And the other aspect had to do with all the kind of power of attorney and remote notary power of attorney rules that could be overlooked, and again, to avoid a whole transfer being invalidated because of something minor. So we see it as a very helpful provision and appropriate under the circumstances. The only thing I was going to add that just hadn't been mentioned, the remote notary public rules, when they were originally enacted a year ago, was for 180 days. And those have since been renewed a couple of times. And most recently, they were renewed on March 19th. So currently, they're in effect through September 15, 2021. So that's how long the remote notary rules are in effect. We'll see if they're extended again. Otherwise, they'll expire on that date. So those aspects of this provision wouldn't apply to, after the effective date of those rules. And otherwise, the only other thing I was going to mention, Senator Sears, you had asked about if there was a discrepancy in acreage. And I don't believe that this statute would have any impact on that at all. That would be completely separate. The 15-year curative provision really only applies to those specific defects if it wasn't sealed, witnessed, acknowledged, or because a license to sell was not issued or is defective. So it only pertains to those very specific circumstances. And if there's a discrepancy in acreage, that would be handled very differently, not just kind of glossed over or cured with this.
Yeah, it would be a much different.
So that's all that I was going to offer. From, again, the practitioner's perspective, they see it as something that would be very helpful, especially today.
Okay. Sounds good. Joe Benning has a question.
This is not for Terry. This is going back to Andy and trying to answer Alice's question. Andy, I kind of felt like it was hanging there at the end of it, but from our old law school days, let's presume nefarious seller sells to you and you put the deed now signed with both signatures into your desk drawer. Nefarious seller the day later sells to Alice and Alice signs and runs down to the town clerk's office and files. Who wins?
Awesome question. So Vermont is a notice state and not a race state. So
You're going to have to explain that.
okay, correct. So if nefarious seller signs two instruments within a minute of each other and both buyers race to the town clerk's office in a race state, the first one to get there and put it in the clerk's hand is the winner. They won the race. Vermont, being a notice state, says, yes, if you are the number two buyer, in other words, I'll switch that around, but suppose the person who got there first knew about the other conveyance. They, in a notice state, they were on notice that they were not going to. So the fact that they sped down to the clerk's office and beat the other person by 5 minutes is immaterial. They are not going to win. They won the race, but we're not a race state. So if anybody as a buyer is charged, if they have knowledge of information, it can become relevant to the priority of recording of deeds.
So
There is actually a case on point. It doesn't happen very often, but yeah, I have seen it applied.
But if they don't have knowledge, the first one wins.
Yes.
First one to the town clerk's office. Okay.
Yes.
Well, thank you. That help? We're going to race to the town clerk's office.
They may not be open.
They're not, but you can make an appointment.
Yes, in most cases, correct.
I
don't-
shouldn't
they don't
say
have-
they're not.
They don't have e-filing.
Yeah, Bennington is not open, but you can make an appointment. Andy, you made one statement, and I don't want to call for a study committee, but you said that Vermont has the most complicated power of attorney laws in the nation. We would certainly invite in 2022 any improvements that could be made in our power of attorney law. I can't tell you how many times that I got asked recently whether I had power of attorney over my wife affairs, and she over mine. And I think we did all that, but it's hard to know. And if you say they're some of the most complicated in the nation, I would invite you and Terry and perhaps some other members of the bar to take a look at that and how we could simplify that. I'm not going to ask them to put a study in here, but I would welcome any changes that could simplify that for both the lawyers as well as the Vermonters.
Thank you. Yes, happy to take a look and come back and visit with the committee when it's convenient.
Terry, if you want to kind of take that on, work with me over the summer, I'm happy to put something together with Eric or some other draft person.
Thanks so much, Senator.
Yeah, I can't tell you how many times this was a corporation, Prudential Insurance, kept asking me if I had power of attorney. I think so. How do I, I remember signing all those things years ago with the, regarding healthcare decisions.
You didn't save them anyplace?
Yeah, they're in you know where they are? They're locked in a safe deposit box at the bank I can't go into.
Yeah, we'll let you in. Just knock on the door. We'll let you in.
Yeah, right. I mean, that actually is one of the, obviously I could probably make an appointment to get
Yeah.
into the Bank of Bennington, but
Yeah.
I actually I did a withdrawal from an IRA from a drive-through window. It did not make the people behind me very happy, but that was how we did it. Things have changed. Anyway, thank you all very much. Committee, and Peggy, we can, would like to take a couple of days, think about the bill, and then we can schedule it next week maybe to mark up and vote. Or would you rather do it today?
Let's take a day or two in case anybody listening has a comment.
All right. Thank you very much. So Eric, I'm not going to keep you here much longer, I hope. But if you want to take 3 minutes to,
You just muted yourself, Dick.
oh, I did, yeah. Could we take a 3-minute break to 10:15? 11:15, I mean.
Come back at
Senator Bruce
11:15.
is muted. Yeah, come back
That's-
at 11.
That's an 8-minute break.
What time is it?
Well, 7-minute break now.
When do you want us back?
10:15.